Objection, Judge. My opponent is being a whiny little... Is that a proper legal objection in New York? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. Your accident case or medical malpractice case goes to trial. And now, during the course of trial, the opposing attorney, let's say it's the defense lawyer, is asking some really annoying, really persistent questions. Now, I get fed up. I turn around, I jump up out of my seat, I say, "Objection, Judge! My opponent, the defense lawyer, is being a whiny little..." Can I say that? The reality is, no, I should not be saying that. That's not the appropriate language for the courtroom. You know, if I have to say that, it means that everybody in the courtroom already knows that. If I'm the one making that observation and telling the judge about it, there's a very good chance that the judge already knows it. There's a very good chance that the jury already knows it. So what good is it going to do if I go ahead and yell out to the entire courtroom and especially to the judge and say, "Judge, my opponent is a whiny little nasty..." Guess what? What's the judge going to do? Turn around and say, "Yeah, counselor, you're right. I know that, now move on." He's not going to do that. He's not going to acknowledge publicly in open court that my opponent is a nasty, whining and obnoxious and complaining. He's not going to do that. And likewise, why should I highlight to the jury and to the judge, and why should I interrupt the flow of the questions that he's trying to ask and the continued annoying, persistent behavior that he's getting everybody? Certainly, if I'm getting aggravated, there's a good chance the jury's getting aggravated. There's a good chance the judge is getting aggravated. Why do I need to highlight that to the court? The reality is that I don't, and I shouldn't. So, a tactical mistake is where the attorney has pushed all of his buttons, and now he jumps up out of his seat and says, "Yes, Judge, my opponent's being a pain in the ass." Well, guess what? If that's the case, everybody already knows it by then. And your attorney jumping up out of his seat and highlighting that fact to the court isn't going to change anything. It's just going to highlight the fact that you, as the attorney, have a short fuse. It's going to highlight and divert the attention that everybody had on the whiny attorney. And that's not something you want to do. If the lawyer is whining and persistent and obnoxious, go ahead, keep going. Keep going, because nothing's going to happen. Nothing's going to happen at all. And the judge is not going to, say, "Yes, that's true, counselor." Instead, he's going to say, "Counselor, move on." That's it. And now he'll tell the defense lawyer to go ahead and move on with his questioning. So why do I share this great information with you? I share it with you just to give you a sense of what really goes on in these civil lawsuits in New York involving accident matters, medical malpractice matters, and even wrongful death matters in New York. You know, I do recognize you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so, and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.
Gerry.